Good to go, Joe.
Okay. We have a quorum present, myself, and let me see here. Alfredo, Michael Bryan, I saw a second ago, and Ginny Farrell. So I'd like to call to order the meeting of the May 13th meeting of the Law, Buildings and Codes Committee. And tonight we'll be taking up two proposed local laws. Local F, which is the prohibition of eviction without good cause. And the other one is local law G, which refers to power to chief of building official to act in emergencies. But first, we want to start off taking public comment, same as we did the last two meetings. And since we have so many speakers, we're going to limit that to 3 minutes apiece. After that, we'll go to the sponsors and committee members. Okay. So.
Hey, Joe, for the record, I'm here as well.
Who's that? I can't see.
Sonia.
Okay, Sonia, thank you. Oh, there you are with your hand up. I need a bigger screen like. Okay, so you want to call the first one, JR?
Sure, give me 1 second.
And I do ask, okay, that you limit your remarks hopefully to F and G. We spent quite a few hours already on H and I twice, okay? So we will be having another meeting. We're trying to set up probably another within the next 10 days. Okay, so please limit it to the two that I just told you about. Thank you.
All right. Oh, and Mr. Kimbrough is here. Just so that we have Mr. Kimbrough, Miss Fahey's here. I apologize, my dog is crying.
I do see Tom Hoey here.
Mr. Conti's here. Mr. Hoey's here.
Okay.
I don't know if you mentioned me, Judy.
Oh, and I do want to mention that Council Member Owusu Anane told me he would not be available this evening. He's involved in students moving out in his ward tonight, and I guess there's some issues, so he asked me to relay that. So
Right,
go
the
ahead,
first-
General.
The first person I have for public comment is Deborah Pusareri.
Okay,
Yes, good evening. It's Pusatier. How are you?
good. Thank you for coming.
Oh, thank you for having me. I would like to speak to, are we speaking about good cause? Is this the good cause portion?
Yes.
Yes, okay. Again, thank you for having me. I've been a property owner for over 30 years. I've been in Albany, actually, is where I started. And I do appreciate everyone on the Common Council doing the best that you can for this city because I love Albany. However, I also recognize as a property owner, and especially I'm in one of the toughest areas. I'm in the ghetto. I deal with drugs, gangs, guns, you name it. I've worn bulletproof vests, letting the police in for a bust in my house, to women prostituting themselves, telling me it's the only way they can feed their children. So I deal with a lot of real life scenarios that for some reason, government doesn't want to talk about or acknowledge that exists with tenants, the relationship between a tenant and a landlord. And I will say this, I know you've heard a lot of arguments against good cause, but the number one argument I have is that as a property owner, the Constitution affords me constitutional rights, property rights. And as a government entity, you folks you all took an oath to uphold my rights. You're there. Government's in position to protect my rights, not strip them. So by working with tenant groups to remove my property rights, to tell me who the length of time and what decision I can make to rent to someone. And then if I feel it's the end of the rainbow and it's just not working for whatever that reason, then I have to go to court, pay an attorney to defend my rights that come with my property. That's not acceptable. And I don't consent to any of this. I will never consent to my property rights being taken. There've been an awful lot of abuse with property rights over the years. And this is just the icing on the cake. And I said this before, the New York State legislature voted this down. They wouldn't even entertain it, said it was not good for New York State. Why Albany is working with Rebecca Girard to backdoor it in the tenant unions, I think is shameful. I do. And I'm afraid that you folks are going to lose your city. You're going to lose your city because people like me, we're not going to stay. You're going to end up with landlords who don't care. You're going to end up with tenants who can't be removed that aren't good for the neighborhood. They're not a good fit. And you say, oh, well, there's things that you can do to evict them. No, you know what? There isn't.
30 seconds.
Yep. My other tenants aren't going to rat on the guy selling drugs out of the apartment because they're scared. And unless people open their eyes and realize what I deal with on a daily basis with the type of tenant I deal with, it's going to be a disaster. And again, you folks don't have the authority to remove my constitutional rights to my
Thank you,
property.
Deborah.
Thank
very
you.
much. Next, JR.
Sean, do you have that?
You were muted, JR.
Sorry. I have Elton McLaughlin.
Hi, thanks for organizing this, everyone. I'm a landlord, and this whole name of this new law, good cause eviction, honestly, that's not an accurate name. Really, the point of this legislation is tenancy for life, and that's where it's damaging to properties. Landlords have to live with tenants that they don't have the option to not renew the lease. And, and that's an important option that landlords need to have. It's how they improve their apartments. But, I would like to take a quick detour to the statewide Housing and Tenant Protection Act that was passed, 2 years ago. Everything that's listed in this law, all 10 of the reasons for quote unquote good cause eviction, those already exist in law. So there's honestly no reason for those to be in here. Some people have raised the issue of landlords not renewing in retaliation for tenants reporting them, for code violations. That exists in the Housing and Tenant Protection Act of 2019. Has anyone really looked at that law? That's something everyone on the council should be looking at. That's already in the law. At the end of the day, this is just going to be an investment killer. If you've got to live with a tenant and the rent is below market, well, what's the incentive to really improve that property and make it a more attractive place to live? And so that is, and by the way, everyone talks about an eviction crisis. Where are the statistics showing how many people were evicted in 2019? Does anyone have those statistics showing what the 2019 evictions looked like relative to 2018 when those protections were not in place? Does anyone? That's a question.
This is public comment, not question and answer.
Okay, well, everyone on the council, before you move forward with this, I haven't heard that statistic quoted in all of these council meetings. What are the actual eviction numbers, and why is that a crisis? Look, when landlords have to evict tenants, it's been 10 years since I had to evict one, thank God. Everybody loses. We don't want to evict people, but we need the ability to do that if things are going the wrong way. And that's not always related necessarily to to violating the lease. Tenants can be difficult to deal with, working with you and in how you manage the property. So those are my my talking points. Thank you.
Thank you, Felton.
I see that Louis Roldan signed up. You also are a city official. Did you want to speak during public comment?
Hi, yeah, my name is Luis Roldan. Yes, I am a senior planner at the City of Albany Planning and Development Department, but I'm speaking today just as a resident of the South End with regards to good cause eviction.
Thank you.
Go ahead,
So-
Louis.
So what I wanted to say, essentially, a good cause eviction, I believe, is necessary in order for us to be equitable to our communities that are most in need. Historic disinvestment in our vulnerable Black, Indigenous, and people of color communities were due to racist housing policies of previous administrations. And Albany participated in that administration of policy that was racist. And already, just within a few minutes of listening to this, I'm hearing racist dog whistles already coming out about being in a ghetto, about having people who will live there in perpetuity, not being able to kick them out, losing the city. This kind of language is very damaging to people of color. It's very harmful. And this just speaks to how the racist policies continue to be administered today, whether it's overtly or covertly. And this is one of the ways that it has been happening covertly. So when I'm thinking about good cause eviction, and I'm looking at the policy, I'm thinking about this as a process of revisiting our policies, examining where they came from, what their genesis was, and asking ourselves how we can do better. When we hear comments like we've just heard just now, and if you don't ask yourself, if you're not thinking to yourself, how is this coming off as a little bit racist? If that doesn't ring in your head, then there's a lot of work that we still need to do on our policies here. So I'm just speaking out here because I think it's very important that our communities are represented, that we are not lost, and our value is further diminished by having an ability to create a sense of community be taken away. I think that there is more than one way to build a community. Homeownership is one way, and the New Deal era saw a lot of white residents be able to build that generational wealth, but our Black, Indigenous, and people of color communities have always been denied that right through overt and covert methods. This is a step in the right direction to being able to afford our communities the ability to build our own communities and have a say in the way our city is run. And I hope that you will consider that in considering good cause eviction. Thank you.
Would I be able to, if you don't mind, I feel a little bit,
I'm sorry, Ms. Pusateri, this is not the time for back and
I've
forth.
been
with other
accused of being a racist, and that's not acceptable. Not a racist, and that's not,
Please.
I'm sorry, we're not gonna have that. This is public comment. We have a list of people who are coming to speak.
and I appreciate that, but I won't be called a
Ms.
racist. That was a
Pusateri, you're out of
personal-
order. You need
Not
to
okay.
stop.
If this keeps up, remove her from the Zoom, please.
Next, we have Kristen Copper.
Hello, my name is Kristen Copper. I work for United Tenants of Albany over on Orange Street, and I'm also here as a local documentary filmmaker. I support both local laws F and G. I believe they will make positive changes for Albany. Good cause will help tenants feel safe in reporting housing and safety concerns. Right now, tenants are afraid to speak up about issues in fear of retaliation from their landlords. Our neighbors are living with leaking ceilings, broken locks, cracked windows, infestations. I've seen these things firsthand, and I've filmed these conditions for my films. Nobody wants to live like that. But our neighbors are scared to report these atrocious living conditions in fear of receiving a retaliatory eviction notice. And these retaliations do happen. I once interviewed an Albany tenant for one of my documentaries who had a leak in her ceiling where water was dripping down onto her kitchen table. She asked her landlord to fix it. They refused. So she reached out to code enforcement for help. Code enforcement came out, filed a report, and immediately the next day, the landlord served her an eviction notice. This is why we need good cause. So tenants, can report these issues and feel safe doing so. Local law F and G are solutions that will help create livable neighborhoods. When people can find decent and stable housing in Albany, we'll have improvements in all areas of our community. We'll have neighbors who want to raise families here, who want to create homes here, who want to invest in our schools and local businesses. Local laws F and G of 2021 will create a pathway forward for beneficial changes that will help our community. Thank you.
Next, we have Todd Drake.
Hello, good evening. I came to speak specifically on a topic, but having heard some of the notation or testimony already, I just wanted to touch on a few things. Someone mentioned earlier that the 2019 Housing and Tenant Stabilization Act at the state level brought forth a lot of these protections that are already being brought out here as the need for this new legislation because renters are unprotected. But this narrative is not true. I understand that there are certain bad actors that exist, both on the standpoint of people who are renting and from the standpoint of people who, particularly out-of-town landlords that don't take care of their property for reasons we don't know. And I think it's important that if our goal here is stabilized neighborhoods and affordable housing, this neighborhoods are stable when have neighbors who can live with one another in harmony, when properties are maintained, okay, and when property managers are able to manage their properties to the best service of their residents. And I think this is important to know. I have 2 properties within 2 months where people moved out because the people below them or above them were so atrociously behaved that they wouldn't stay and they wanted to find better neighborhoods and communities. And that to me is a tremendous failure of our system. The reason for that failure is because we've been unable to effectively manage our properties. And so while some of this is inflicted by the COVID moratorium measures, other problems are afflicted by the 2019 Stabilization Act. The proposed law only goes a little bit further in certain areas. One area is in the 5-month renewal notification that is rescinded by the resident. It's not reasonable because it is essentially agreeing to a perpetual lease. The second thing is in controlling the amount of increase that can be applied to a lease. This doesn't necessarily help in affordable housing. What helps in affordable housing is incentivizing and also helping to support financially the creation of new and more affordable housing. When you look at this consumer price indexes, for example, right now, staple food products are up between 9 and 11%, depending on category. Insurance is up 9%. Okay, employment costs are up somewhere around 25%. Yet what we're proposing is that a property owner would be regulated by the city in terms of what he or she might find to be a reasonable rent increase over time. I think that's working backwards. When you consider that in order to maintain properties and provide a high standard of living, the property owner needs to be
Mr. Drake, I apologize. I didn't give you your time frame, but your time is up. But if you want to wrap it up, because I didn't give you a 30-second warning.
Okay, thank you. In short, we all have the same goals here, but it is not a good idea to penalize law-abiding, good-acting property owners with blanket restrictions that may help with some cases that are unique and or egregious where property owners have acted irresponsibly. I think that is important that code and city officials punish and otherwise, cure those bad actors, but not to make it at the expense of all the other good actors. Thanks for your time.
Next, we have Peter Cook.
Hi, my name's Reverend Peter Cook, and I'm a homeowner in the city of Albany. I live in District 6, and I also serve as executive director of the New York State Council of Churches, which advocates for just housing policies and property restoration in communities in every part of New York State. One of the things I find really frustrating as a resident is that there are just too many poorly maintained rental properties all over the city in much greater proportion than in other communities in New York. And I'm also frustrated that people have to pay too much for renting these properties. These two factors put my fellow residents in financial peril and cause them to have bad health, which puts them in more poverty while fraying the social fabric of our communities. This kind of property and economic damage and its human cost devalues all of our properties, whether we are landlords or homeowners. Good cause eviction is one positive step we can take to encourage landlords to keep up their property and not cause economic instability to tenants or themselves, the landlords, by precipitously being able to evict people, especially if those residents complain about maintenance issues which make their dwellings unhealthy or unlivable. To be sure, this law merely reinforces what good landlords, many who be on the care of their property, already doing. This is not for you. This is for other landlords, many who don't even live here, who are not doing what good landlords should be doing. And this is directed at them. And these folks should be forced to keep up their property and not evict people. It also ensures that these wayward property owners don't hurt the property values of the vast majority of landlords who do keep up their property and are treating their tenants well. Good cause also
30
protects
seconds.
the property values of homeowners because people are more inclined to buy in communities which are not so economically unstable or are saddled with blight. So we strongly urge the passage of good cause evictions, and I thank you for this opportunity.
Next, we have Marshall Miller.
Thanks. Good evening. So regarding good cause, personally, my tenants are my neighbors, most of whom I now consider friends. I wouldn't dream of evicting them for any reason that doesn't involve a good cause. And even in that case, it would be an extreme last resort. I think a lot of us small landlords despise eviction court as much as our tenants do. It's expensive to hire a lawyer. It's intimidating to go before a judge. Likewise, with lease renewal, I cross my fingers that my tenants will renew their lease. I think so much of how this is framed, and I think Reverend Cook framed it this way, and I would like us to think sort of beyond tenants versus landlords, but the way in which landlords protect other tenants and neighbors. So let's say, for example, you have a tenant who moves in who seems like a reasonably nice guy, he pays his rent, but you're soon hearing from the female tenants who live in the building that he's making them uncomfortable in the laundry room, he's hanging them out, he's asking them personal questions. He's finding and following them on social media, sending them direct messages. You've heard that he's asked at least one of them out. Women are starting to complain to you as the landlord. So what do? You talk to him about it. He dials it back, but you're still hearing from your female tenants as well as from neighbors in the area that they're generally feeling uncomfortable and unsafe around him. And some have even moved out sooner than expected because of this. A guy like that affects the entire neighborhood. So his behavior may be creepy, but he's not technically violating any law. Your lease doesn't cover this because it's hard to imagine any scenario, all these scenarios in advance. When I read about the proposed law, good cause doesn't apply here. He's always careful not to be at the level of a true nuisance. And the question is it seems to me that good cause prevents the landlord from at that point telling him, hey, when your lease is up, I'd like you to find a new place. And you're just in the idea of an environment that you would want to create as a landlord, as a feminist, as a dad of two daughters, as a human being. I would like to retain the power to be able to deal with situations like this. That's a very specific example, but I think these types of situations can abound. Consider the case of a tenant who has a Confederate flag on his car and posts racist stuff on social media, which other tenants have found. They say they feel uncomfortable and safe. Are you allowed, as the landlord, with proper notice at the end of his lease, to tell him it's time to find a new place? And what if he refuses that? Do you then hire a lawyer and go to eviction court and turn this into a legal battle over free speech and good cause?
30 seconds.
And I want to be clear, for all of our sakes, I hope we're not encountering too many creepy tenants or certainly Confederate flags in Albany, but these basic problems here apply in many situations. So as we all know, this good cause law will be the first of its kind in New York State. Like any law that's trumpeted as groundbreaking, I strongly encourage thinking through the unintended consequences and drilling down in more detail about exactly what reasons for good cause may be and what would fall under what would be a nuisance. This stuff is
Thank you,
complicated.
Mr. Miller.
I
Time's up.
appreciate it. Thank you.
Next, we have Fred Floss.
Hi, everybody. I'm Fred Floss. I've lived here in Albany for almost more than 10 years. A lot of my friends have been very passionate about speaking about just the ups and downs of living here. And I really think that this good cause eviction legislation would go a long way in the right direction. It would not solve everything, but it would definitely provide a solid framework for helping to give power back to a lot of tenants who could just be made homeless for reasons they don't have the money to fight back or elaborate on. As far as statistics go, I mean, in New York State alone, as of January 2019, an estimated like 92,000 something New Yorkers experience homelessness on any given day. And that's in 2019. As of 2021, 800,000 to 1,230,000 New York rent households in the state aren't able to pay rent and are at risk of eviction. This is an epidemic. This is affecting people who do not have the means to live safely and securely. And now, would good cause legislation make it impossible for landlords to evict tenants that have a problem? I don't think so. I think good cause eviction, there's still plenty of room for plenty of reasons to evict a tenant from their housing that violates a multitude of statutes, like the non-payment of rent, violating a substantial obligation of their tenancy. The tenant is committing or permitting a nuisance, such as maliciously damaging the apartment, for instance. I mean, if you read the law, I'm seeing a lot of language that does, I think, even in regards to the testimony I've just heard, still provide plenty of protection in that case. And just in terms of security, tenants not being evicted means that there's a greater investment in that community, in the neighborhood, to feel safe in your own apartment and to feel like you have a support system. That's something that's a two-way street between tenants and owners. That's something that takes work. And that's something that goes beyond these bad faith actors cited in this testimony. It's as far as a power differential, people having like the sort of Damocles over their head, whether or not they'll be able to live or whether they'll have to risk homelessness and be at risk for whatever that means, that won't make the neighborhood a safer, better place.
Time is up, Mr. Floss.
Thank you.
Next speaker, we have Kaushik Vijaykumar.
Hi, I'm Kaushik Vijaykumar. I'm speaking as both as a homeowner and a renter, homeowner in a different state and renter in New York State. I do believe the good cause evictions is the right step in the right direction. Both as a homeowner and renter, I've seen the two ends of it. As a renter, I've been with landlords who do not respond to you. Have lived in houses which had molds, which had leaking ceilings, and it was almost impossible for landlord. And it makes unsafe living. It can cause cancer. You have nowhere to go to. So good cause evictions does help the tenants who are in such dire need with a way to get help, with a way to move ahead and live in a safe environment. Not only that, the good cause evictions not only help the renters but also the landlord, so that they can provide a community where people can live in harmony when safety and you invest in your own community. So I did hear comments where people were talking about whether, well, not all tenants can be evicted. What if you have unruly behavior? The bill does support behavior where the tenant, if they're unruly, if they're against the comfort of the landlord or the neighboring occupants, that the tenants can be removed according to the good cause eviction bill. So it does support specific arguments where tenants are creating a nuisance, not only just damaging the property, but also interfering with the comfort of the landlord will be removed based on the bill 3328 and bullet point number 3. So so when you look at the bill itself, it is helpful both for the renters and for the landlords. It is going to invest in our community. It's going to build a sense of community, harmony, and a harmonious living for the people. And nobody wants to leave a property unless and until they're going to buy their own property. So being evicted with a short notice or like a week's
30
notice,
seconds.
for not just the renters, but also for the people living in the community, because you're living in a sense of uncertainty on you. Today you have a place to live, and tomorrow you might be on the road because the rents went up or the landlord decided to raise the rent by 30%. Because being a homeowner, I have seen property values go up 30%, but the rent's going up only by 2 or 3%. Why? This helps.
Time's
build
up. Thank you.
Yep.
Next, we have Gabrielle Recchio.
Recchio, you got it. Thank you very much. My name's Gabe Recchio. I'm a resident of the city of Albany, and I'm here to speak in support of passing local law F. I think that it's a huge problem not having this law in the books in the city of Albany for what's already been mentioned, that there is a disincentive for tenants to stand up to their property owners. And to address a prior bit of testimony directly, property owner mentioned that they haven't had to evict someone in 10 years. Well, if you can just not renew someone's lease, it sort of makes sense that you haven't had to evict someone in 10 years. I want to also agree with what Kaushik just said. I think that where people lay their heads at night is a very special and sacred place. And we have a huge amount of renters throughout New York State and throughout this community. And there's no reason that folks shouldn't feel secure and empowered to better their living situations by working with their property owners. And the reality is that right now, without local law F in the books in the city of Albany, that's just not the case. Thank you.
Excuse me. So from who I have in the queue versus what I have listed, I'm just going to read the names from the list that previously signed up. Stephen Negron.
Present. I'm going to take it as my opportunity to go ahead and speak. My name is Stephen Negron. I'm actually running for city council in the 3rd Ward of Albany. I'm a local activist. I've got a lot of things to say in a short amount of time to say it. A lot of the rhetoric that's been going around recently has been kind of like propaganda, as far as like saying that landlords wouldn't be able to evict tenants when there's over 10 clauses that would support a good cause eviction. Someone named Mr. Miller brought up a scenario about a creepy guy making women uncomfortable. Well, unless his lease doesn't have a clause that protects the peace of mind of his other tenants, which every lease that I've ever signed has had one, then that is very much a reason that supports a good cause eviction. Albany has a housing crisis. We have deteriorating properties, and people live in squalor and are now asked to pay more as opposed to what they had to pay 10 or 15 years ago. Now, another myth is saying that landlords wouldn't be able to raise their rents. Well, what we have now is landlords that have dilapidated buildings that raise rents with no good cause. good cause eviction would support any landlord that invests in his property and increases its value to absolutely raise your rent. But if you have a slum, you shouldn't be charging $1,200 for the people to live in. In 2019, which was pre-COVID, the average median income for an Albany resident was about $25K. Now, if we go over by the golden rule of not paying over or just paying 1/3 of your income to sustain yourself, then we're dealing with rents that are about $700. The average median rent in Albany, South End, or the ghetto, as someone else referred to it was nearly $1,300. So in all seriousness and in all consciousness, how do we expect people to live and get by? And then we also ask questions as to why is the violence upticking in Albany? If you think that the if you think the Albany housing crisis and the violence aren't tied together, you're in for a rude awakening. Because as people find it harder to get by and harder to make a living, they resort to illicit means. It's human nature. Doesn't matter what color or demographic you're talking about. So I am in strong support of this bill. It is something that Albany is in dire need of, and any good landlord would support it. This is not an anti-landlord bill. This is an anti-slumlord bill. This is an anti-corporate developer bill. And this is an
Thank you, Mr. Negron.
tenant bill. So that's all I have to say.
Next one, Kashana.
Next, we have Rosie Lewis. Is Rosie Lewis in?
I do not see them here.
What about Lorenzo Murray?
No.
Luke Grandis?
Not here either.
Samantha Vasquez?
Not here either.
Canyon Ryan? Stephen Schwartz? Charmaine Brockington?
Not here. I see next on my list, Mr. Raguso.
Thank you. Can everyone hear me?
Yes, sir.
Thank you very much. So I want to go on file to opposing this local LF. And as a landlord and with only one house, I feel that this local F will definitely bankrupt the small tenant or the landlord. For the simple reason is you're putting the mom and pops out of business. We all talked about good tenants there. I want to tell you from 2020 to 2021, I have not gotten a full month's rent out of my tenant. He closed his business down prior to the shutdown of everything with this pandemic, and I have not got the full month. Every month I got to write him. I say, your rent is due. And so in February, I write him, I says, your rent is due. And he writes me back and it says, you know, I'm saving for a car. And that was it. So you know what happened for that month. And so I says, you got to get a job. And I says, I'm going to tell you what, the transportation you have is no good. Get transportation. I want to send you to Amsterdam to be interviewed for a job. So he finally did get a transportation. I sent him to Amsterdam. He gets interviewed by the boss up there. He was offered a $50,000 job plus overtime, hospitalization, dental, optical, profit sharing, and yearly raises, and he refuses it. And I still have not gotten my rent. So I went beyond. I called down to the Port of Albany, and I was going to talk to Rick Hendricks, but I talked to the secretary. I says, can you tell me a little bit about the $350 million building you have down there? She says, yes, an outside country is going to come in and build a $350 million building, and it is going to build wind turbine bases. I said, well, how are you going to train everyone? We're going to train them over in Hudson Valley. I said, good. When do you think it's going to start? She says in the second half of this year into the first half of 2022. I said, fabulous. Do you have information? Yes. She sends me the information. I send it to the tenant, never acknowledged it. And so now we're into the month of April, which I haven't gotten any rent yet. So I write him, Alan, the rent is due. He writes me back and he says, you know, I had to buy a car. It was more than what I
30
anticipated.
seconds, Mr. Ragusa.
Okay, it's more than what I anticipated, and I have registration and all these other bills. So me as a landlord, where do I stand? How do I go in this September and pay my school taxes? How do I pay my property tax come January if I got a tenant that doesn't pay and you tell me I have to have good cause to evict them? No way. Thank you, guys. I really definitely oppose this. I don't believe this law should pass. I think it should go by the wayside. Thank you very much.
Thank you, Mr. Raguso. Next on my list is Glenisa Gaylord.
Good evening, everyone, and thank you for taking the time to allow us to speak this evening. I'm hearing a lot from tenants and tenant advocates, as well as landlord advocates. One person or one party that's not been heard from in this matter are homeowners. We as homeowners invest in this city. Where we buy a home with the hopes of being there for as long as possible. Sometimes it's 5 years, sometimes it's 10 years. I've known people who've been in their homes for 50 years and more. So we are investing in Albany. One of the great things about Albany is the diversity of its neighborhoods. Sometimes we have landlords that are in the neighborhoods who don't do the right things. At the same token, we don't have tenants that do the right things. I am opposed to this law as it is written, not because of the spirit of the law, because I do believe that landlords who are not keeping up with their properties, who are not making sure that, not making sure that their properties are in good order and thus keeping up my investment in this neighborhood should have some repercussions. But at the same time, we as homeowners have no say in what tenants they put in there. And we really want to encourage landlords to bring in tenants who are going to uplift the neighborhood, who's going to be a positive contribution to the neighborhood and live harmoniously with the other homeowners who are there. I have been a resident of Albany all of my life. I grew up in the South End, now live in Arbor Hill. I have my father's been here as well as my family for a very long time. Again, living in the South End and the Arbor Hill, which are two of the most economically challenged areas in the city. But I've invested in Arbor Hill because I believe in its potential. I love my neighbors. I love my neighborhood. Unfortunately, we as neighbors and homeowners have to deal with tenants who do not feel the same way. I've dealt with people drug dealing in front of my house, prostitution in front of my house. I've dealt with all these other people in the middle of Clinton Avenue, a very busy street, mind you, drunk, yelling, belligerent, people grilling in front of their homes, which is a fire hazard. And with all of these row houses, if one house goes up,
30
all
seconds.
of them goes up. So I really want you to think about how this affects owners. And please, please, please think about having the law give landlords who are good landlords the ability to get tenants out and reform how this works, because it affects everyone, not just tenants, not just landlords, but homeowners as well. Thank you.
I have Aaron Seamus. I have Hunter Share. I have Jenna Kirsten. I have Michael Crowell. Sergio Adams.
His was just written. Mr. O'Grady?
You're mute, sir. Unmute yourself.
Yeah, okay, got it. Well, as I mentioned at last Monday's meeting, or Tuesday, it would help if the two sides got together because there are excellent points on both sides. And some of the, but what I'm going to do is just kind of try to answer some of the issues that the landlords have with this bill. For example, ending leases is how landlords improve their apartments. In the case of most good landlords and most good tenants, that sort of situation, I think, gets resolved. I'm not speaking from the point of view of a landlord, but I have been around the city for a very long time. I think that can be done. In the case of a bad tenant, yeah, very difficult. If the rent is below market, how is the landlord to make a decent profit, which is what he is in business for? There is a clause in the law which says that significant market changes would obviate the need to follow the 5% rule. Let's see, statistics. Yeah, this is something someone should have gotten out in the beginning. United Tenants, of course, has these statistics, and we should get them out there. There have been a lot of evictions, a lot of unfair ones. Marshall's creepy guy and the racist guy, he's got some good points, and I think that in decent situations that these things can be worked out. But I don't have the time to think about it as long as Marshall did, so I'm gonna wait on that one. Lastly, yeah, tenancy for life, the rights of a property owner. People have a right to stable housing. The right to stable housing is not written as clearly in the law. In fact, it's been written into the law opposing stable housing. It's not written as clearly as the rights of tenants, as rights of landlords. I think that what this bill does is even the score a little bit. I don't think it's as damaging to the small landlord as it may seem. The pandemic is damaging to the small landlord, that's for sure. Vince is a good guy. He doesn't deserve
30 seconds
in the bind that he's in. I would say that the bind is caused by the pandemic and not by, and that, you know, defeating this law is not going to help a guy like Vince. Thank you, that'll do.
Thomas Vandor.
Yeah, good evening. Thank you. So I'm strongly opposed to local law F and G, frankly. The proposed law is really tantamount to theft of my property by the city in this case, and transfer of that property to, to non-owner tenants, people who have not put in the sweat equity and the investment required to buy, purchase, and maintain a property. So neither the city nor the tenants it caters to in this case really owns the property. I own the property. So there are no provisions in the Constitution, my deed, nor my mortgage, frankly, that cede control of my asset or what I choose to charge as rent for persons whom I wish to lease it to, privately by mutual contract or agreement or consent. That's my first point. My second point, really, grounds for removal in section 30-328, echoing Marshall Miller's point, they contain way too many subjective provisions, leaving little to no room for discretion, particularly with regard to the section about nuisance behavior. One tenant's normal behavior, may be disrespectful or threatening as interpreted by somebody else or differently by any other individual observer. So it's very subjective. So these are my main points for today. I'm also opposed to the notion of having to, give 5 months notice to, for a prospective termination of a lease agreement without knowing that, or knowing in fact that the tenant could at any time refute that or not, refuse to consent. This is not their property. And there's a lot of rhetoric about, who owns or whose property, whose housing this really is. Well, if someone's put in the investment to purchase and maintain a property, well, it belongs to that person. It does not belong to the city, nor does it belong to the tenant or resident or occupant. So these are my points, strongly opposing this law. And I truly hope that you take that into consideration. Thank you.
That's John Parody. He was in there. And the last one I have for public to speak is Deborah Williams. I don't know if John Raphael Jr. has any additional that I don't have.
I'm looking over right now.
I was on the list to speak as well.
Mr. Silva, yep, you are just going down. Go ahead.
All right, thank you so much. So we've heard a lot of arguments today that absolutely have nothing to do with good cause eviction. There have been many examples brought up that would have been absolutely covered as a good cause for eviction, which is exactly what this bill is trying to do. I like the point that somebody else brought up recently, that a situation like a guy being creepy around the neighborhood, that's extremely subjective, and anybody can call somebody else creepy. What if there's a racist living there and he finds the black guy creepy, and he's just going to keep calling him that until he gets evicted? And so we're basically saying that we're going to give people absolutely no protections in that sense. Then at the same time, somebody else was asking earlier for statistics. 5,000 evictions per year in Albany pre-COVID. That is a lot of evictions. And when you have a community where 5,000 people are being evicted every year, that is a lot of destabilizing going on. So people need stability to find jobs, to keep jobs. Students need stability so they can stay in the same school as all of their friends and not have to move to a completely different district every other year. So when you have a situation where people's lives are being uprooted like this, nobody can have a sense of home. You don't get a sense of community. Poverty becomes worse. And guess what? That's when you end up with this crime happening everywhere, with some landlords feeling like they need to wear a bulletproof vest to walk around their neighborhood. Guess what? That's a result of poverty. And evictions for no reason, arbitrary evictions, which is what we're against here, only make that worse. So if you really care about the value of your property, of your home, of your neighborhood, if you truly want investments to be coming into Albany, you should be doing whatever you can to lessen poverty in the area. That means taking care of tenants, taking care of the people in Albany, so that you no longer have to deal with that kind of crime. And good landlords want this bill. I know many landlords, small landlords and bigger landlords, who want this bill because there's an epidemic of blight and dilapidated housing across Albany, because the current system we have incentivizes landlords to evict their tenants rather than fix their properties. So if you truly want properties to get better across Albany and have Albany be a more inviting place for investments and businesses to come in, then you want good cause eviction. So these properties are actually being maintained. Tenants actually have a right to stay. And none of this, some landlords are also making a
30 seconds.
Sure, like this is the state coming in and taking away all of your property rights. That's not happening whatsoever. You still have the right to that property. You can still evict your tenants. You just need a good reason to do so. And last, that comment somebody made about a Confederate flag in their car is funny, because I was going to say the same thing. What if your landlord is the one with the Confederate flag on his car and he wants to evict somebody with a Black Lives Matter sign on their window? That's not something we should be allowing landlords to do whatsoever. So we need good cause eviction in this city and statewide. Thank you very much.
All right. I have, let's see. Maria Moskovitz. I thought I saw her. I guess not. Okay. Mr. Parardi, are you able to speak now?
Yes, I'm here.
Oh, wait, go ahead.
Okay. I oppose this too. I wanted to thank everybody for their comments, and we'll try to keep it brief and add on. I am is this for me or who is this?
Yep, it's for you. Were you asking it, Mr. Parardi?
Yeah, who are you looking for?
John Parodi?
Parodi? That's me.
Parodi, yep. Okay.
Okay.
Go ahead. I'll restart your
Sorry.
time. It was for you.
I heard some.
Go ahead, John.
I think he has Facebook in the background at the same time because I
Oh,
hear.
is that the problem? I'm sorry about that. Okay, can you hear me now?
Yes.
Okay, so I oppose this. I'm one of the good landlords. So how do I close the, something's wrong here. I'm sorry. So sorry.
We can hear you.
Okay. Can you hear me? Okay. Okay, well, I oppose this. I'm one of the good landlords. I often get tenants who come from other landlords who don't do a thing for them. I'm very visible. What concerns me is, my goal is, I have 6 properties. What concerns me is my tenants, is the financial burden. Being stuck, you're never going to get that money back from tenants who you can't evict. Okay, $20,000, for example. I've seen people, that far in debt. So hopefully you can hear me. But I don't appreciate like my choices in tenants and getting rid of them or renewing their lease being dictated by somebody. I just don't think that's right. It could be costly and nobody wins. I think we should work on a better solution, first of all. And I also, I've had very few problems, and when I've had to get somebody a dispute, it's very challenging, and it's just nobody wins. So as far as that goes, I have very strict guidelines as a landlord. I want to contribute to the city, and I want to make a good living. So please reconsider this. I would be happy to work with somebody about making this beneficial for both sides. And that's really what I wanted to hear. I also was a little offended with Luis's comment about the racism because I worked very hard to get my properties and I'm way in debt and I'm making a contribution to Albany. I'm good for the economy. And I'm constantly putting money back in and making Albany a better place to live and a good place for people to live. Thank you.
Mr. Chair, there were several people who are signed up, but I do not see them here. I want to open it up to anybody else at this point, sir.
We won't any longer, okay? We've given it an hour of comment, and I believe we have a couple of other pieces to take before us on top of this, okay? So why don't we move ahead and opening up questions to members of the committee first and then other council members. I see Mike O'Brien, your hand's up.
Joe, can I
What?
can I take a moment to go over the
Oh, I'm
bill?
sorry. Go ahead, yes, I'm sorry, you're the sponsor.
Some miscommunications about the bill, and I just want to make sure everyone is very clear about what this bill does and so forth.
Unmute yourself, Alfredo.
Can you guys hear me? I'm doing the phone thing. Can you hear me?
Yeah, we can hear you, Alfredo. Yeah.
Now we can.
Okay. So
keep your phone up though, because once you move it down, it cuts off.
Let me. Can you guys hear me this way as well?
Yes.
Yes, go.
Okay, I apologize. I have internet issues, and sometimes when I speak, I lose the internet, so that's why I use my phone as a backup. But that also creates echo issues. Uh, Thank you, Joe, for giving me time just to go over the bill. I understand it's a very controversial bill. I understand the emotions on both sides. I am a landlord myself. I own 3 properties in the city of Albany that are rental units. I live in the 2 units myself. I know the struggle of small landlords. I bought my first property in 2006, working at the YMCA, making $30,000. So I know how hard it is to make your mortgage. I know how hard it is to save, to put everything you have, to invest in your next little property, and then save and build to invest in your other properties. I get it. I get the sacrifice that's made by landlords. I get that this has been a hard year for landlords. It has been. And we were not eligible for any PPP. We've been asked to take on a heavy burden, and we have not really gotten much relief yet. And I get that. I get that, and I understand why there's so much fear from landlords about this. But I want to go over the bill because I feel like there's a lot of feeding of that fear that is escalating people's anxiety about this. And I really want to make sure people understand that a lot of the issues that were brought up today are protected by this bill. And a lot of the concerns people have are protected by this bill. And I also want, so let me start off with property rights. And then I'll go through the 10 exceptions. So you have property rights and you have rights of association. This bill does not affect owner-occupied properties if it's less than 4 units. So if you live in a property that you rent out, a second unit, this does not affect you. You have rights of association. Those are your property rights being held up. So this does not affect you. I want to make that very clear. For others who have non-owner occupied properties, like myself, I own 2 other properties that I don't live in. Those are the ones that are affected by these policies. So I want to be very clear. So when people are saying property rights, you still have your property rights of the home that you own and occupy. But when you become a landlord and you rent non-property occupied homes, there are always stronger regulations. And all my real estate friends and all my landlords know that. You know that. So I respect that, and I respect that we in this legislation are also respecting that. As far as this being free rent, this is not what's going on because of the pandemic. I want to make that very, very clear. The pandemic is a one in a generation situation. And it's a situation I hope my son never sees. So it's a 1 in 100-year situation. And the regulations that have been put on landlords, regulations that are going to expire, just like the mask mandate is expiring, so will those. And for many landlords, and depending on what side you're on, some people fear that expiration. Some people are hoping it comes because there have been people who have abused it. And we have to be honest about that. We have to have honest conversations so we can get to a better place. So this does not affect that. The number one reason you can evict, first reason is not payment of rent. So if someone doesn't pay you your rent, that is a good cause of eviction. That is there, that is protected. Under that, and I know the controversial part is the 5%. So the 5% is to protect individuals who are addressing concerns with landlords that landlords either don't want to deal with or just don't want to deal with that individual anymore. So they want to raise the rent above 5% with no good cause to raise the rent. That's when it's not a good cause if you've raised the rent more than 5%. However, in that section, if you raise the rent because you've made improvements to the property, that is protected. If you've raised the rent because there's been market changes, that is protected. If you raise the rent because the activities that are being done and the conditions that have been done in the common area, so not just in the units, but in the common area. For example, if you added a washer and dryer, and you had to do plumbing, you had to put in the machine, that is a common area improvement. That is grounds for an increase. So even with the protection of rent, it also protects several of the reasons that people are fearful of not being able to raise rent. What it does not protect is saying, I'm going to raise the rent by $400 from $1,000 to $1,400 because, I think this tenant is annoying. And we've all had annoying tenants. I get that. But it's not right to evict somebody because they're annoying. It's not fair. It's not fair. And it's also not fair for neighbors, because many times they're being annoying because of actions from other people in the tenants. So if your landlord, if your tenant is calling you because somebody else is playing the music to 2 a.m, that's something you've got to address. You've got to address it. And if you don't, then that's not a good cause to evict the person. B, a violation of lease. So if they violate your lease, so if your lease says there's no smoking and they're smoking in your property, you write them up. You call them and you follow up with an email. So you have it in writing. And if they do it again, you follow up again. And then if they do it again, then you take them for eviction. And now you have written proof of multiple conversations that you've had to try to deal with a lease violation. The problem some landlords have is that they don't want leases. And those are the landlords we need to address. The landlords that are here, I guarantee you, most of them have leases. So if you have a good, well-written lease, then you will be protected. If you don't have a good, well-written lease, or you don't have a lease at all, then you are leaving yourself vulnerable. And why do landlords not have leases? Well, there's a little trick. If you don't have a lease, you have to only give a 30-day notice. That's the trick. You don't have a lease, all you have to do is give a 30-day notice. Depending on the state law in 2019, depends on the number of years that they lived. So it's 60 or 90 days, depending on the amount of time that they've lived in the property. But that's the trick. Most good landlords have good leases. They have good leases. And if something comes up in their time of being a landlord, they add it to their lease. I mean, there's something that happened to me today with my tenant that I'm going to add to my next lease, because you learn and you grow, and that's part of being a good landlord. The third reason to evict someone is creating a nuisance. And here is where the gentleman's concern about a tenant sexually harassing other tenants comes in, because it clearly states if it interferes with the comfort of the landlord or other tenants, that is good cause. So it will be the job of the landlord to call and have that difficult conversation with the tenant, and then follow up with an email, and then follow up with another email, and then follow up with an email, other email, and then say, now I've got good cause. I've given you an opportunity to correct your errors, and now there is good cause. Fourth reason. So if I commit a crime and I have to give up my property. That is a good reason for eviction. And there are protections for tenants on that. But if the landlord is in violation of uh, civil or criminal penalties, that is a good cause for eviction. Now, if the tenant commits a crime, that's number 5. If the tenant is doing illegal activities in the home, so say, hey, I'm gonna go one casino nights every Thursday, come on down. Well, that's against the law. You can't have an illegal casino in your home, okay? That's a good cause for eviction, okay? So a lot of the issues that were brought up about prostitution, about drugs being sold in the property, you know, that would be a good cause for eviction. If they're breaking the law and they're using your property to break the law, that's a good cause. Can you guys still hear me? Just give me a thumbs up.
Yes, sir.
Okay, good. Where was that? Was that 6 or 7? Oh, 6. Refusal of access. So if you are a landlord and you're trying to do a showing, or if you're a landlord and you need access to your building, you know, and your tenant is not giving you access to your building, that is a good cause for eviction. So, you know, I know there was some questions about being able to, you know, get into a building and make repairs. You know, most of us have it in our lease that we have to give 24-hour notice to our tenants. So you would have to follow your own guidelines and give good cause if they do not give you access. 7, if you are in a month-to-month lease with somebody and you need to move somebody in from your family, say your in-laws, or say your mother, or say a sister, a brother, or a child, someone from your immediate family that you need to move into that unit. And the units, it's less than 12 unit buildings. Okay. Now you still have to follow the same guidelines that are made up by the state of giving proper notice. And we're going with the city. Or if you have a lease, you have to wait for the expiration of the lease. You know, you've got to still honor your lease. However, that's a good cause for eviction. If you need to have someone from your family move into that unit, that's a good cause. You still have to follow the leases, but that's a good cause. 8, if it's less than 5 units and you are going to move into the property and make it your own personal home, that's a good cause. Again, you have to follow the same laws of notice, but that's a good cause for eviction. 9, if you're selling the house and you're under contract, okay, and again, same notice applies. The state, that's the state, but that's still a good cause for eviction. And 10, which is the most complicated, I think, is if you have given a tenant notice, 5 months notice to renew, and they have refused to renew, and then you go out and find a new tenant and sign a new lease with a new tenant, and then that new tenant, then that old tenant wants to, you know, stay an extra month or 2. Well, no, they had the opportunity to renew the lease when you offered that opportunity 5 months before it was due. And now you have the 5 months to go and find a new tenant, and you found a new tenant, you signed a contract with a new tenant. So the tenant that wants to stay beyond the lease, but that's not a good cause. So it's a good cause for you to remove them because you gave them the opportunity. You gave them the opportunity to renew a lease. They refused to renew the lease. So as long as you have that notice that you've given them that opportunity 5 months before the lease was up, then that gives you 5 months to find somebody else. So I understand a lot of the hesitations. I understand a lot of the fears. But if you read it, if you go through it, and you read out a lot of these situations that are being brought up, a lot of them, the majority of them are protected. The majority of them are protected. And again, I understand the anxiety. I understand the fears. I get it. But I think when we do this, we're protecting individuals whose landlords do not want in their properties for bad reasons. And the perfect example I have is you have two tenants who pay you their rent. Both live in the same house. Both pay you every month the rent, no problem. One tenant plays the music at 2 in the morning, but never calls you, never bothers you. The other tenant is calling you all the time because the person is disturbing them who plays the music to 2 in the morning every day. Who's the bad tenant? The one that plays the music, or the one that never calls you? Or the one that calls you all the time? And that's who we're trying to protect. We're trying to protect good tenants who are trying to do all the right things, but are in bad situations where the other tenants may not be seen as problem tenants because they don't call. But the good tenants who do want a better living situation do call. So that is the basic of why we're doing this. So I appreciate the time you've given me, Chair. I'm open to take any questions, and I know corporate counsel's here to make sure I don't say anything that gets me in trouble. And I want to say this, I appreciate the conversation that we're having from both sides, because I get it. It's very personal to both groups, and I think it's good that we're having this discussion, and I'm glad we're having it and able to clear up any misunderstandings or misinformation that's been put out there. Thank you.
Thank you, Alfredo. And I don't know whether to ask you or that Mr. McGee, before I get to you, Mike O'Brien, you might be on the same line. The state law, okay? The 10 things that you just read, how many of them are covered or not covered in the state law? My point being, in 2019, the state passed this law that says one of the strongest in the country, all right? So probably around June in 2019, so you got 6 months, or probably 8 months until COVID hit. So courts weren't open, okay? Courts still aren't open fully. And I mean, has that ever gotten a chance that all of a sudden we have to, just review everything? There's something we don't like, we want something in there, and we're using the foundation of 10 points that are already covered to do some other things, the 5% change or whatever. That's what people are asking me.
Well,
and is any of the weakness, Bob, is it in the courts? Is it in our courts?
Well, to address the difference between HSTPA and what's proposed here is that HSTPA does provide for extended notice provisions for evictions. But even before HSTPA, a lot of the grounds that are actually set out here are grounds for eviction currently. So obviously non-payment of rent has always been a ground for eviction. Not paying or not obeying your lease has always been a grounds for eviction. The difference, though, is that under the current law and under HSTPA, it is still possible to evict a tenant for no reason, simply because you've terminated the lease. What this law does essentially is it puts the burden on the person seeking an eviction warrant in Albany City Court to articulate a good cause for issuing the eviction warrant. And again, a lot of those good causes, they're causes, you can get an eviction based on them currently. But you don't need to articulate it if you simply say that you're ending the lease. So that's the difference here.
So couldn't we have just done a simple, I don't know, simple saying that? I mean, some of those corrections, instead of repeating the 12 or 10 things are already laid out in law. And I mean, that's what people are asking. What is Albany doing? When basically, probably 80% of it is already covered in state legislation. That's what I had to ask for on behalf of some constituents.
Sure, absolutely. Yeah, I mean, the reason it needs to be drafted this way is because if you are going to end that simple lease termination as a grounds for eviction, you need to articulate, what you're replacing that with, and this basically does that. It kind of, what this law will do is it layers over the existing law, and if someone is seeking an eviction warrant, it asks them to specifically articulate one of those grounds where they're not asked to articulate it now.
And if they were articulated to a judge in court right now, then he wouldn't take that into consideration? I mean, it's...
Right. Well, the judge would take it into consideration, but in reality, landlords typically get around that by simply saying that they're ending the lease, and that obviates the need for the court to actually investigate whether or not there is a good cause for the eviction. And what this does is it changes that dynamic. It makes it so that the Albany City Court is going to engage in an inquiry with the landlord and the tenant to explore whether or not there is in fact good cause for the eviction. And like Mr. McLaughlin said early on, a lot of these grounds are the grounds that landlords typically pursue an eviction for. So, it should not be difficult or much, it shouldn't change the fundamental dynamic of an eviction, except that it forces that conversation to happen in court, and provides the tenant an opportunity and the landlord an opportunity to figure out whether or not there is in fact good cause for the eviction. And the result of that is to stabilize, the landlord-tenant relationship, reduce the number of evictions, and there are a lot of, positive knockoff effects that are going to come from that in terms of, decreasing precarity, increasing neighborhood stability, which is going to, decrease crime. I mean, there's just a lot of positive benefits to that.
Okay. Mike O'Brien's been waiting. He has his hand up.
Okay. Can you hear me?
Yes.
Yeah, I think Alfredo did a great job of explaining what the ordinance is trying to do, and I respect Alfredo both for his experience as a landlord and as a council member. I do have some questions. Some of the comments I thought were very good. I think Glenessa Galliard, who is an attorney who commented as a landlord in Arbor Hill. She basically had some problems with it as written. And she's on our planning board. I think she has a very good idea of housing in the city of Albany from her planning board experience, and from her landlord experience. So, I do take question that I think maybe we need a second look on some of the other problems. I think John O'Grady made an excellent comment both last Monday and tonight that an advisory board might be a good idea. I don't know how that can be written into the statute. I know we have advisory boards in the city of Albany on all sorts of things that involve consumers of service and providers of service. So I think that's a good point. I know some of the landlords who have commented against this. I certainly do not think that they're racist. In fact, I don't think anybody who commented tonight against it as a landlord appeared to me to be doing racist dog whistles at all. And certainly Glenessa didn't see it that way either. I think some of the other landlords, Kukushik, and Stephen Negron and Gabriel Silva, I think they went through obviously they have read it and they have experience, and they said, well, most of these protections are already common sense, and most of the time you have difficult tenant, you would have these provisions within the law. And then Joe's questions raise some of the same issues which I have. I mean, I'm an attorney. I don't pretend to be an expert on landlord. I did mostly healthcare law for the state health department and mental hygiene law as an advocate. But in my retirement, I spent about 4 years volunteering with legal aid with homeless veterans. And some of that involved landlord tenant in the city of Albany. And I do know as a matter, and this was all before 2019, and I do know for a fact that for the most part, the judges in Albany City Court were sensitive to hardship issues in terms of delaying evictions. And we even had a retaliation claim that we could pretty substantially prove enforced. The tenant wound up spending the best part of a year. And this was under state law, the old state law, which I think is, as Bob McGee has stated, pretty much had these same protections. They got strengthened in 2019, but I did want to read something that was in the Bar Association Journal explaining these laws in 2019 so that I don't discredit, or attribute wrong motives or reasons to the landlords that have raised issues with them. I know, and I'm quoting the Bar Association here journal in one of their 2019 issues specifically on this law, and they're quoting the New York Times, which reported on the rent control issue, that economists from both the left and the right are in almost universal agreement that rent control makes housing problems worse in the long run. And I certainly don't regard either the New York Times or the Bar Association Journal as using racist whistles. I think that was a very objective critique. And then, the question which comes to me was the 2019 law allowed cities outside of New York to basically go into these, housing board situations and have such things as rent control and these additional protections. But the city had to do something first. They had to do a legitimate survey and show that 5% of their, no more than 5% of their affordable housing was vacant at any point in time. We never did that. So I guess I'm saying, is there a legal fight that we're going to face? Are we trying to jump over some of the requirements in seeking further restriction or further protections? Are we trying to jump over the requirements that the New York State 2019 law put in place? I know I raised that issue with Bob McGee, and I think he made some amendments because I know I got a mail from Bob with a revised version, which I haven't gotten to read yet. So he could answer that question. I mean, yeah, I don't think anybody on the council, wants to see people paying poor people paying $1,300 average rent. I know with the few veterans that I dealt with, and most of them were looking at studio apartments, and just a studio, one person in Albany and this was in 2018. The cheapest we could see was about $850 a month. So I know there's a problem there. I don't know how a lot of people even manage to live. But I appreciate some of the concerns, but I also appreciate the fact that the law does have a lot of landlord protections. But I am concerned whether we are somehow jumping over what the 2000 state law, it gave us an avenue for enacting some of these further ones, which we didn't do. So that's my concern, and I'm open to I'm open to any way of fixing this. I know Judy had some concerns, which I'm sure she'll probably mention, about the wording of the 5-month notice. But that's where I'm coming from, and I appreciate. I think Alfredo gave an excellent presentation, and he's got the experience to see inside the issue for sure. And obviously it's trying to solve a real problem, but does it have a few glitches in it? That's where I'm coming from. That's all I have to say.
Okay, Sonia, you're next.
Alfred, were you gonna respond to Mike, or I don't want to jump the gun?
If Joe, if you can just add me to the list.
Go ahead. You have some?
That's okay. It's just,
No, go ahead.
okay, I appreciate that. And thank you, Mike, for your comments. And I appreciate those. I think there's a lot of misinformation put out there that this is rent control. This is not rent control. This is not going to lower rent. This is not going to lower rent to anybody. This is, if your rent is $1,300, it's not going to be $1,100 after this. It will be $1,300. What this stops, it stops the loophole. It closes the loophole of the non-renewal as an eviction process for, you know, getting rid of tenants that the landlord has no good reason to get rid of. That's what this does. That's what it does. It closes that loophole. And the 5% is to make it so that a landlord doesn't jump the rent from $1,300 to $1,800. That's what the 5% is there. And what that allows the landlord to do is renew with a 5% increase, which I think for $13,000 it'd be roughly about another $80. So rent could still go up to $1,380 the following year when they renew. It just can't go up to $1,800. So, you know, so it's not rent control. What it is, and I just want to be very honest and blunt, it closes the loophole for bad evictions with the renewal. That's what it does. And the 5% is there to make it so that landlords don't use it, jump in rent as another way of trying to close that loophole of allowing landlords to evict tenants that are following all the rules and doing everything right. But for whatever reason, they want to evict them. And many landlords know if you have a good tenant, you know, very rarely you're going to even do that 5%. You're not gonna raise that 5%. Maybe you do $25, maybe you do $50, but most likely you're not gonna do $80 because you don't want to lose a good tenant. You know, so why would, well, that's why I gave this scenario of what does a landlord consider a good tenant? The person that plays the music to 2 in the morning and pays the rent on time and never calls them, or the person who pays the rent on time or calls them all the time, complaining about the person that plays the music? Who doesn't get renewed? You know, and that's the problem. Who doesn't get renewed most times is not the person that's playing the music at 2 in the morning, because they're paying their rent. It's the person that calls and is trying to correct the issue and is seen as a annoying tenant. But they're just trying to correct the issue. And sometimes landlords feel either powerless to address it, or they don't live in the neighborhood and feel like, well, I'm getting my rent from both units, so why am I going to mess that up? They may play the music till 2 in the morning, but they're paying their rent, and you know, I'm not going to get rid of that person. So I think that's the goal, is to try to get landlords to address the tenants that are not following the rules, while not penalizing those that are following the rules and are complaining about rules not being followed either by other tenants or by the landlord not taking care of their property. So that's what this is. And I just want to make sure that's clear. And if we want to have a debate and a discussion about whether we should close that loophole or not, that's fair. That's absolutely fair. But I don't want it to be miscalculated as if this is rent control, because it's not. If someone moves out, but they're moving to, I don't know, moving anywhere. I'm not going to name another state that's sunny and warmer, but they're moving anywhere. The landlord can then take the property and go from 13 to 18. Okay. Doesn't stop them from raising it for the next person. So what it does, it stops them from raising it from the current tenant who's following all the rules. And like I said, most scenarios, landlords won't even raise the rent to good tenants 5%. I don't. If I have a good tenant that's going to renew, like it was said by another landlord, if you have a good tenant that's going to renew, you want them to renew. Because it's better to know the devil you know than the devil you don't. And that's the truth. And the landlords who are in the room, tell me if I'm wrong. If you have a good tenant, are you going to really try to raise them out of moving, of staying in your home or staying in your, you're not. You're not. So
Okay.
I just want to make that clear.
Thank you, Fredo. Sonia, you ready?
Thank you. And thank you for the continued conversation. I think it's very important that we hear both sides on this issue. So I do really appreciate that. My question tonight is going to go back to number 10, just like last time, because I'm still trying to make sure I'm understanding and, and the like. So what is the basis of the 5-month notice? Like, what was used to determine 5 months?
Rob?
So the basis is, I'm sorry, can I speak, Joe? I apologize.
Yeah.
So
Go
the
ahead.
base,
You or Rob?
okay. I'll speak, and Rob, if you want to add anything.
Oh, the only reason I ask is Rob drafted originally.
Yeah. So the basis is if you're a landlord and you're looking to renew a lease. So I understand that landlords, you want a very low vacancy rate. A lot of people think that landlords are millionaires and living the high life. Most people who know me know my niece doesn't even want to drive my car. So, there's no high life being lived here. So you want to keep a low vacancy rate. You want to make sure your properties are constantly occupied, because one day of having a vacant property, a vacant unit is income you can never get back. It's not like, if you don't sell a car today, you can sell it tomorrow. No, landlords make their revenue through time and space. If the space isn't being occupied at a certain time, that's lost revenue they can never get back. So, this is actually there to protect landlords. So if a landlord is looking to renew a lease and they give their tenant 5 months renewal notice, have a conversation with them. Say your lease renews in June. You have a conversation with them in December. Hey, you want to renew a lease. Your lease ends at the end of May. June 1st, you want to do a new lease. Oh, I'm not sure what I want to do. Right now, I don't want to do that. Okay. So then you send them an email. Hey, just want to follow up on the conversation. I want to give you the opportunity to renew. The terms will be the same, or the terms will be, this will be the new terms. It would go from June 1st to, I want to give you the option to renew. If you don't want to renew, please let me know. If you change your mind on renewing, please let me know. Okay, tenant says, I'm not going to renew. I don't know what I'm doing in June. So landlord goes out and starts trying to find a tenant, because you want to make sure you have a new tenant June 1st. So it's now February. They've gotten access. The landlord, they've done showing. February 15th, because you can't do it on Valentine's Day. Let's do the 15th. You've got a tenant. They sign a new lease. Okay, wait. You've got a new tenant June 1st. Whew, you're going to be okay. So now, April comes, and you tell your tenant, okay, I want to set up a walkthrough for May, because you want to do your walkthroughs at least 2 weeks to 3 weeks before your end of your lease. So if there's any issues, you can address them, and they're given an opportunity to fix the issues. So it's now May, it's now April, and you're giving them, telling them, hey, I want to renew, I want to do a walkthrough. And then they're like, you know what? I don't want to leave at the end of May. I'm thinking of leaving in July. Well, no, you can't do that. You were given an opportunity to renew a lease in January. You were given an opportunity anytime until the landlord had a new lease to get to renew. So until February 15th, they had an opportunity to renew a lease. So come end of May, they have to vacate the property. And if they don't, then that's a good cause eviction. So, it's complicated and it's confusing, but it gives tenants good notice about renewal, good notice about if they're not going to renew. It gives them plenty of notice to be able to do so, as well as it gives landlords plenty of time to be able to find somebody to renew and get a tenant. So it protects both. It protects both. It is complicated, the way it reads, and I get that, but it gives the opportunity for both landlords to have plenty of tenants to have plenty of notice about renewal, as well as landlords to have plenty of time to try to find a new tenant.
If I could follow up to that, I appreciate the explanation, and definitely understand the inner workings, albeit owner occupied, also a landlord Alfredo. But I'm curious to why 5, and why was that number chosen specifically? So for example, why not 4 or 6? Either way, like, I'm just wondering why 5 was chosen.
I think 5 protects both tenants and landlords more. It gives landlords more time to try to find somebody. If you're looking to find somebody, in a 5-month period, and it gives tenants more time to know that, hey, you want to renew, now is your time to renew. So that's why I think it's 90 days, maybe I think you have to give 90-day notice. I know you have to give 90-day notice in the state, but this actually, I think, gives both tenants and landlords more time to actually try to, one, gives more time to tenants to find or figure out what they want to do, and it gives more time for landlords to be able to find another tenant and still stay within the good cause guidelines.
Thank you.
No problem. Thank you.
Ginny Farrell, please.
Thank you. I have questions about that part too, and that part 10, and I just find the whole thing. So I have to say, I fully appreciate the good cause evictions. I think it's important, and I appreciate all the sponsors bringing this forward. I didn't have any questions on Monday because I'm comfortable with that. I was able to ask and I thank you for the very first meeting, because I was able to ask all of the different questions that I had. And but this is the one sticking point that it really doesn't make sense to me. So one of the things that I feel like I kind of need to do, especially with this new legislation, is to fully understand it from the tenant perspective and from the landlord perspective. And I just find it very confusing. I don't know how it's enforceable. I don't know. I mean, the whole thing it's kind of doesn't make sense to me. And I have to say, I was a tenant for many, many years. And there was a lot of, I wouldn't have wanted that 5-month clause, because maybe the landlord would say like, I don't know, and say you should move out and find someone new. And I'm like, I don't know what I want. And so I feel like that's, I don't know if, I think Sonia's questions on the time period should perhaps be thought about a bit more, because at least from my time and I've never been a landlord, I've only been a tenant. So I don't know from the landlord perspective, but I can say from the tenant perspective, I wouldn't have wanted that time period. And I lived in places for years. It wasn't as if it was me moving around a lot situation. It was, I didn't want to move. But then there were times that, I don't know, that seems like a difficult time period to me but again, my question is the only way for a landlord to get out of a lease that they don't want to be in through eviction? Because that seems problematic too. There are situations. So I think the smoking thing is a really good example. and again, I take this from the other, so I have severe asthma. If somebody continued to break the smoking rule, I can't be around them. Like that is, I'm not going to say it's like a death defying thing, but it's a very serious condition for me to be constantly around cigarette smoke. I can't do it. And I would definitely end up in the hospital a bunch with it. So if I happen to live in a place where somebody was smoking regularly that was violating it, and so that this is a real example that one of my small time landlords that again only owns like a couple of properties, I would say that they're similar to Alfredo in all manner. Like I would have loved to rent from you, Alfredo. If I don't own a house anymore, I'm going to try to rent one of your apartments. But so for me, waiting those months while somebody's continuing, it just, like, I think about situations like that where sometimes it seems like there's no flexibility at all. The only way for the landlord to remove someone that they don't want is through eviction. Is that accurate?
No, I mean, you know, again,
I should clarify, if the tenant doesn't want to leave,
then yeah,
the only way. So the landlord, like, let's say this tenant, and again, like, I have examples on both sides where we're all people. Some, you know, like, we're not going to have anything perfect no matter what your category is. So I have examples on both sides. So if there is a landlord who has a tenant who's outrageous and not a great tenant, and so the only way, like, they can't just be like, listen, this person is not stopping smoking, and I have somebody that's continually in the hospital that has been here, living here for 15 years. I don't want them to leave, but they're going to leave because I can't remove this person who continues to smoke, even though, you know, they could just end the lease, but they're not allowed to end the lease.
So
if that person wants to stay.
So let's digest that situation. So, and I've had that situation happen to me, where I've had a tenant who who felt I pay rent, I can smoke where I want. Well, no, you can't. And I've had to deal with that. So let's digest. Right now, if I had a tenant that didn't want to move out, even though they're breaking the lease that says you can't smoke, or even if the lease expired, I would have, and they still don't want to leave, I would still have to take them to court to have them evicted. Now,
So-
under this, that would be good cause because they're breaking the
Right.
lease.
But you have to understand, along with that is a whole process.
I get that. Now, there's other ways.
So, which can, and the other thing is,
Guys, let's.
I'm sorry.
can I just follow up with more questions, just because I would say this is my time to talk and your time to answer.
Yeah.
So, sorry. But so when it comes to housing court, it's already, even without, I mean, I don't know if you guys have looked in the timeline of housing court, like eviction court is already months out. So aside from the pandemic, that was the case before the pandemic. And so this would create, I would think, an even so much more. So I just, it's like, and my other question is this even, like, if this is challenged in a court of law, because I will say, so Rob, Corp Counsel always comes to us and is like, you're going to get sued. Is this going to be able to be, is this specific clause on the lease? Because I don't, like, there's a whole freedom of contract thing. So, like, is this specific clause actually going to be able to be upheld in a court of law? Like, good cause eviction stuff, I think that there's a lot of thing, but and again, I'm not an attorney, but from the different read that I have, I'm not sure that it would actually be able to be upheld. And then I also would like to bring up the whole concern about what is this going to do on our court system, which was already overloaded. So have you guys factored that piece into it? If the only way to remove someone is through eviction, then you know what I mean? Like, what, have you guys factored that in and considered that as part of the process?
You want him to answer now?
Yes,
Rob Levine?
thank you.
Okay, so let me
Rob
just,
Levine, you asking Rob or Alfredo about the court?
can I give you my
Well,
landlord?
the court thing, I think Rob would probably be better off with, but I have really been appreciating Alfredo's input. So
I'm gonna give you my landlord experience. So, if someone is smoking and breaking the lease right now, and they don't want to leave, I would be forced to take them to eviction. That's the law right now. I cannot change the locks on them. I cannot pick them up and say, you gotta go. I cannot take them out and say, you're creating an unsafe environment for my.
You could not renew their lease.
Even if I didn't renew the lease, and they.
No, I'm just saying that, let's say, because that's the way that was the example that was used with one of my landlords was they kept fighting. And then they were like, and they said, if you keep doing this, we're not going to renew your lease. It wasn't as if like they were very, and they didn't. And so that seems reasonable to me to say, if you continue to violate these things, like it almost like a good cause not renewing your lease thing, as opposed to having to go through the whole court system, which is already overloaded.
So, okay, so let's take the end of a lease. So the end of the lease right now, if my tenant said, I'm not moving out, even though the lease has expired, I would still have to take them to court to evict them. And the reason I would evict them would be because the lease expires. Just because the lease expires doesn't force anyone to leave.
No, but you don't have to renew a lease.
But it doesn't mean they're gonna leave. For me to actually get them out of the building.
No, I mean, like most people are reasonable and they're not gonna just stay. Like most people, they would leave with a non-renewal of lease. Anyway,
No, and that's what you can do. Like you can tell somebody, and you can pause for removal.
Can we move
That's
along?
the
Back and forth?
Well, I want to also finish this statement.
I'm just super confused, honestly.
Most landlords are going to, a tenant that's problematic like that, are going to probably tell them, listen, you've been a problem. I can get you out to eviction, or I can get you out by giving you back a security deposit and go home. That's what most landlords are going to do. That's what I did. I had a person, same issue, smoking, and I have a no smoking policy. And I was very clear. I can either take you out to eviction because you're violating the lease, or you leave me the apartment clean.
I have to be honest, Alfredo, I don't understand. That doesn't make sense to me in the question I'm asking, but I know JR's hand is up and maybe Rob can help too.
Maybe JR can explain something here. And Richard's had his hand up for a long while.
Rob, do you want to go first and then I can jump in?
Yeah, sure. I think I can address some of these points. So under the proposed local law F, you can terminate a lease, but the simple lease termination alone without demonstrating good cause is not going to entitle the landlord to a warrant of eviction from Albany City Court, which is an order to the sheriff's office to go out and dispossess someone of the property. So under the law as it is, and under the proposed law, like Alfredo was saying, even if a landlord says they're terminating a lease, the tenant can say, well, I'm not accepting the termination, or you didn't terminate it correctly, and they can hold out. And yes, you would ultimately have to get an eviction warrant issued by the court if you wanted to move that tenant out of the property. As far as whether the law, if it's challenged, will hold up, so speaking about the U.S. Constitution, obviously, government in general has the ability to regulate this transaction, this landlord-tenant transaction. It holds up under the Fifth Amendment because it is not an inverse condemnation. It does not rob the landlord of the economic benefit of the property. So we're good on that grounds. There is a concern, or the first question you would ask is whether or not this law is preempted by HSTPA or the existing eviction law. I don't believe it does. The question you have to ask there is whether or not state law fully occupies the field of rental housing regulation, and I don't think that it does. When we're talking about evictions here, we're talking about a very specific legal proceeding. It's under Article 7 of the RPAPL. It's a
Yeah.
summary, right?
And I'm not, it's, so the evictions part I get, it's this part 10, it still doesn't make sense to me. It doesn't make sense that somebody can say, I don't want you here anymore. And maybe the person doesn't want to move and they're like, no, I want to stay. It's not necessarily a hostile thing when ending a lease. It's actually like an eviction is a hostile act, which it should be. I don't have a problem with that. I don't even have a problem with good cause lease. And there's some people that spoke that really connected that. Like, I don't have a problem with that either, that if you're ending the lease and you have good cause, but the fact that you'd have to go to eviction, you'd have to go through an eviction court proceeding to just end a lease when you have good cause to end maybe it should be a good cause to end the lease too, that you have to have a good reason, so you don't actually have to go to eviction court. To me, that doesn't really, I think it's creating a huge bottleneck that already exists. Would you agree, Rob, that there's a bottleneck in eviction court? Because from what I know, knowing judges and lawyers and everything, there's a bottleneck there. And
I wouldn't disagree that there's a bottleneck. And this law won't make that any worse. Because again, when landlords are going to court, they have all of this evidence and they have these reasons for pursuing an eviction kind of in their back pocket anyway. And one of the things we tried to make clear in the law, one of the changes that was submitted this afternoon, is to clarify that if there is a voluntary agreement between the landlord and the tenant to end a lease and the tenant moves out and the landlord's okay with it, that's 100% fine. As long as that transaction is not brought before the court's not going to intervene on that. Landlords and tenants are still free to end the lease like voluntarily on whatever terms that they agree on.
So my one request, and then I will not talk anymore. And Joe, thank you so much for being tolerant of me. I appreciate it.
Everybody there, not just me.
And everyone else. But my request is that we could have something in there where you could do a good cause lease ending as well. So that people would not have to go to eviction court, because I think that, and I'm sorry, JR still has his hand up. So that would be my request, and I'm done.
JR, you're up.
Yeah.
Yep. So just real quick, with Ginny, with your example of a violation of the lease, as opposed to then just evicting them, terminating the lease, that's actually what a lot of landlords, from what I understand, do, is as opposed to, okay, we're getting close to the end of the lease. What can I do? I can just terminate the lease, or I can do a notice to cure. What's the difference really? The notice to cure, in any notices in landlord tenant court, you have to serve it by a service of process. You have to do either on personal service or nail and mail. And if you hire a process server, you're typically looking about $30 to $40 just for one notice. So in the circumstance that you're looking at for a notice to cure, it's a 10-day notice that you have to then serve upon them. And if they didn't cure, a notice to cure, you then have to then give them a notice to terminate, which would then give you a right to go into eviction court. So depending on your lease, in order to give a notice of termination, depending on your lease's length, you're looking at, let's say a 1-year lease, you're looking at a 60-day notice now. So I have to give you a 10-day notice, and now I'm giving you a 60-day notice to terminate your lease because you violated this provision. And if you don't leave, now I have to go back to court saying the notice to cure was valid, the notice of termination was valid because of this issue. Whereas when you're weighing the costs of all that, most landlords, from what I understand, would just bypass and say, I'm just going to terminate the lease because it's quote unquote cheaper in essence, and it achieves the same means.
Well, the tenant would have to hire an attorney too, so it gets expensive both ways.
And then on top of that, in terms of the courting issue, I actually have to disagree with Mr. McGee. There is a backlog from what I know and throughout the states, especially in my time when I was a court attorney in landlord tenant law downstate, it is a backlog. And what the 2019 Act did that was different from before that is everybody has a right to an adjournment for the first one. And with an adjournment, you do depending on dockets, and I know in towns and villages, you're looking sometimes as a 2 to 3 months wait for the next court date just because a person's entitled to an adjournment.
Okay. Richard, for your patience, thank you.
Yeah. trying to think where I want to. So I think some of the concern, the issue that I have, and generally I'm don't have a concern with the overall thrust here, but I think some of it goes back to the issues that Ginny is raising, trying to wrap my head around the provision that basically doesn't allow a landlord not to renew a lease at the end of a term without having to go through an eviction proceeding. And I understand some of the concerns. I'm trying to go back and forth. And part of it also is, and maybe it's going back to some of the issues that I thought Glenissa hit on some of the issues that I'm thinking about, and how a poorly managed property can have a really negative impact on a neighborhood. And a property can be poorly managed either because the landlord doesn't care or is absentee, or therefore tenant behavior might not be controlled, or the landlord maybe sees too many hoops to go through to sometimes addressing issues. And non-renewal of a lease is sometimes a way that you can deal with a problematic tenant without having to go through an eviction proceeding that might be costly and time consuming. And so I'm just trying to wrap my head around that whole issue in terms of how do you streamline that process without, and I think is what was Ginny was raising, without really having to make it an eviction proceeding and taking away the ability of a landlord to decide for reasons not to renew a lease. But that is, one of the areas that I'm trying to still wrap my head around in terms of how that all works. And that's one of the concerns I have. So I have a quick question, because I know Alfredo had referenced something about, it's important to have a good lease with whatever your expectations are in there, but raised the question about, on renewal, if there are issues that you need to be addressed. I think you said something about adding provisions to a lease. And if upon renewal, a landlord decides to add provisions to a release to try to address issues that he or she was dealing with, is that a lease that under the current way this bill is structured, that the tenant would have to accept as a renewal, or can the tenant simply contest and say, no, I have a right to renewal of the lease I currently have, and you can't change the terms of what's in that lease? That's a question, I guess, I don't know, for Alfredo or for Rob.
Legal question.
Yeah, I mean, I'm not sure that there is a legal right on the tenant's part to the exact same lease. And there wouldn't be under the proposed law. And then to address your first point, so yeah, like I was saying before, the law does not, the proposed law does not require a renewal of the lease. It just says that if you want to, based on the non-renewal, go to the Albany City Court and get an eviction warrant, you're not going to be able to do that unless you demonstrate good cause for the eviction. So you still have the ability, and in 95% of cases, the tenant is going to hear from the landlord that I'm not renewing your lease, and the tenant household is going to make other arrangements to move out. But if for whatever reason the tenant household is unable to move out at that point, under the current law and under the law that's proposed here, the landlord is, if they're going to force the tenant household out of the home, they're going to have to pursue an eviction warrant. Again, under the law as it is and under the law that's proposed. The only difference is under the law that's proposed, the landlord, when they get to court, they're going to have to articulate one of the good cause grounds for doing so.
I might disagree with you in how I see it, but another question I have is on one of the good cause is if you're selling the property and the condition is that the property be turned over to the new owner free and clear of any obligations, which would mean that if the property has current tenants and the new owner wants it free and clear, the current landlord would have the right just to terminate those leases regardless of what the expiration is, correct?
No, I think the terms of the leases would trump or govern, that particular transaction. It just would be that if the landlord came to court and the lease was properly terminated and was no longer active, the landlord would be able to obtain an eviction warrant if they were able to present proof that they have an enforceable contract for sale.
So if
that
the term of the
requires-
lease extended into the period where the new ownership took possession of the property, that lease would continue when the new ownership took over, but would the new owner then have to offer a renewal or would be able to not renew? If they, again, because there's an issue where the property, the new owner would want the property free and clear of any obligations.
Well, presumably the new owner in that case, I mean, they would never get involved in the eviction themselves if they're going to insist that the property be given to them without tenants. But if you have a lease, if the tenant has a lease that says it's good until January 1st and the landlord selling the property, they have a contract for sale that says they need to evict by, December 1st, that landlord is not going to be able to do that. They're not going to have been able to, that part of the contract, they're not going to be able to meet that part of the contract for sale, the term of the contract for sale, because they're not going to be able to obtain an eviction of the tenant by that time, unless the tenant voluntarily moves out, either deciding they want to work with the landlord or perhaps the landlord selling the property can provide them some sort of incentive. Again, one of the things I want to emphasize here is that the additions that we made today, they are meant to protect those sorts of voluntary agreements. And the hope is here too, that, the good cause laws will encourage landlords and tenants to work together so that, the ending of tenancies is less disruptive to Albany neighborhoods and to the households themselves, so that they can come to, agreements wherein the tenant household has time to find a new home, and the landlord is able to move in a new tenant if that's their desire, on terms that are favorable without needing to get an eviction warrant.
I'm not sure.
Richard, just as a standard practice, many leases from my practice and seeing it, many leases do contain, there's not state law regarding on this matter of if they sell the property, that, they're automatically evicted. There's nothing on the books on that one. Many standard practices in lease, though, that from what I've seen in my time, is that they have those provisions where it says if I'm selling, the lease is terminated. That's been standard practice from what I've seen.
Okay, and that provision would continue under this law as well.
Yes, under this provision, it would.
Okay.
Okay.
Again, the area that I still have to figure out is the non-renewal issue and how that's being dealt with.
I don't think we're having any motions tonight, are we? If there's not, how many people we have left here? 1, 2, 3 committee members? 1, 2, 3.
Jenny Farrell, Michael Bryan, and yourself.
Oh, sorry. Okay. Well, what's the sponsors? Anyone?
Judy hand is up.
Who?
Mr. O'Shea's hand is up.
Okay, I just want to, okay. This agenda has us taking up the next local law, Local G also. So if we're going to need another meeting on this, we're going to start the other one, or we're just going to go for a couple more hours.
I think Judy has questions.
So,
I would suggest another meeting. Hear Judy out for sure.
where is Judy? I don't see her. Oh, okay, you're up in the corner now. Go ahead, Judy. Judy?
Thank you. I don't think I have questions so much as a couple things I think are helpful to clarify. So there's talk about why there's 5 months notice being given, why there has to be 5 months notice. What I think that whole provision says is, and I think Alfredo, I wasn't completely following everything that Alfredo said, but I think Alfredo said basically, if a tenant can't decide and then the landlord goes, gives them 5 months notice, and then they go ahead and they decide the landlord leases it, well, then the tenant needs to move out or they're a holdover. But that would not be a legal eviction under paragraph 10, because there needs to be the consent of the tenant to the agreed termination of the lease. The end of the lease comes and goes on a 5-month, if somebody has a lease, let's say for a year, and there is agreement, the landlord wants that person out at the end of that lease term, the landlord can give them notice and give them and basically say, and you have the right to refuse to move unless you consent and to this. And then at that point, the landlord can't lease the apartment. And well, the landlord could lease the apartment. The landlord simply would not then be able to go to court and do an eviction proceeding based upon the fact that he now has a new lease executed with somebody else. Because he entered into that lease, he didn't meet all the terms, the conditions of paragraph 10. So paragraph 10 says you need the consent before you can enter into that lease if you want to use that particular paragraph to be able to bring an eviction proceeding in court. It is a protect. I mean, this whole law is really protections for tenants to continue in their premises, in their apartments. So I just wanted to make sure, as people are, thinking about this, and Rob, tell me if I'm wrong about what I, tell people if I'm wrong about that. But I do want to just cover a couple other things. Richard's gone at the moment. I'll cover something else. I also want to make it clear that if it's a month-to-month tenancy with no lease, then the landlord's only ability to get rid of somebody is by voluntary agreement that we're now parting ways and you're moving someplace else. And the landlord cannot bring an eviction proceeding until that person stops paying rent, I guess, or there is one of the other 9 causes. So for a month-to-month tenancy, there's no basis to actually bring an eviction proceeding unless for paragraphs 1 through 9, one of those causes. Richard, with regard to your question about whether or not somebody is entitled to continuing under the existing lease terms, if somebody has a year's lease, let's say, and all those terms exist, and they're coming to the end of that lease, and a landlord decides, I want to add new terms, the landlord can offer a lease with new terms, and the tenant can then decide whether or not to execute that new lease. If the tenant does not execute a new lease, then the tenant continues on a month-to-month tenancy, and the prior terms of the lease are understood to be incorporated into that particular lease agreement, unlike a month-to-month, for which there may not be any lease terms, no written lease in which specific terms exist. In a written lease situation, I have been told by a couple attorneys who know something about housing law that under those terms, the conditions of the prior written lease would continue. It is then a month-to-month tenancy on which the landlord can only terminate it if it meets one of the good cause requirements in 1 through 9. So that's just some additional things. I would really, I don't know if Rob has covered the changes that he made. I'm only aware of one change that he made in the legislation. I do think it would be helpful for him to go over what amendments he made, because I don't think we got a red line version of that, of the new law. So those are you know, I want to say that, that I struggle with this. I struggle with this because I support the idea of somebody being able to stay in their home, especially being able to stay in their home, not having a retaliatory eviction based upon the fact that they have made some sort of a comment to code. Even if maybe they're not the best tenant, maybe the thing to do is to put a provision in here that protects somebody under those kind of circumstances. But the idea that there are something or add something to the nuisance requirements or violations of terms, I think it should be okay for a landlord to have conditions associated even with a month-to-month tenancy, certain rules and regulations, that the violation of that would be a basis for a good cause eviction. So I think the legislation needs some work on some of those issues. Thank you.
Well, I would like to
Joe, you went muted.
maybe it is time to move on. I think I'd like to get a red line version and see what those changes were. Okay, they were hard to pick out and we got it rather late today, Rob. So do I have,
Sure.
what's the committee want to do?
Well, I would make a motion to adjourn
Okay.
with the idea that we've covered a lot of ground. I think it's been a super productive conversation.
I would like to, at least, I don't think Richard's piece would take that long to, I mean, we gotta, because if we come back next time, this one could be just as long. Richard, it only has to do with power to chief of building officials to act in emergencies.
Yeah, so I'd like to just defer Rob to, I think it might be non-controversial or not as controversial, but I'll defer to Rob to basically explain this one or to both.
That sounds good to me. Okay, so there's no, your motion hasn't been seconded yet.
All right, so this is a pretty simple one. It's it's very much a housekeeping bill. So the local law F, it switches out the title of commissioner for chief building official, which I think is just easier to work with. You know, it's a less, because it's not contingent on the title. It refers simply to the person in charge of the building department at any given point. It degenders some of the language, and then it changes or amends some of the language regarding the recoverability of the costs of performing emergency work at a premises to make it easier for the city to recover. And those are really the three changes: the chief building official change, the degendering of the language, and then the change to the recoverability language.
Local law F or local law G?
F.
Okay.
We're talking about G.
Oh, is it G? I'm sorry.
Yeah, G.
That's what I thought. Okay.
George.
Thank you.
Just one, let's see. So
I don't have any problems with it myself.
I don't either.
I don't either. I would be happy to make a motion to move forward with it.
I'll second that.
Okay, good.
All those in favor? Committee members?
Aye.
Aye. Okay. Alfredo here for, okay. So.
I'm not a committee person.
All right.
Just a quick question on this, I guess, for Robert Rick. I mean, I don't know if it makes sense to hold this until the whole package is put together, or if this
That's what
is
they want to do if we
set
can.
to move on Monday night.
No, I believe they want to do it as a package.
Yeah,
Could we pass it through the committee so we don't
Yeah,
have
yeah.
to worry about it, and then then we can, when it doesn't, we don't have to vote on it Monday.
Yeah,
night,
no.
but
I move it through the committee.
Yeah.
I'm just saying, we can hold it.
With a favorable recommendation and to be held.
Right, I can hold it until the whole package is done as opposed to moving through passage on Monday night. That's fine. That's all.
I have a motion to
Just
adjourn.
to,
And I'm
I would
going,
make a motion to adjourn.
I would second that.
and I'm going to ask for the clerk to set up another meeting for this one. She's already setting up a meeting for H and I, so this one would be after that. I don't think we could take 3 of them up in one night.
We'll follow up, Joe. We'll follow up on that
Do
one.
you have any dates? Do you have any dates in mind already, or?
Well, I think Danielle come up with a couple. June.
Okay, great.
Yeah, we were looking in June, so I can pull them up. I can follow up with the committee.
And I would just caution, I'll be reaching out to members. June is a significant month for many members. And they might want evenings free. Just keep that in mind.
And I am expecting a new grandson in a week or so. within the 2 weeks.
So Joe has a more
Congratulations.
significant event.
Be number 3 in effort. So,
That's great.
okay, so that's it, gentlemen, ladies and
We,
gentlemen.
it was a second, so now we need the all in favor.
All those in favor,
Aye.
put your hands up. All in favor. Aye. Okay.
Yes, thank you.
Thank you all.
Night, everyone.
Thank
Have a good night, everyone.
everybody. I'd like to thank the public for taking the patience, listening to us, and having the interest in helping our city out the right way. Thank you.